Welcome to A Conversation with History. I'm Harry Chrysler of the Institute of International Studies. Our guest today is Luc Walleyn, who is attorney in Belgium specializing in immigration law, human rights, and humanitarian law. He is a former president of the organization Lawyers Without Borders. Luc, welcome to Berkeley.
Thank you.
Was there an a heavy ethical component in what you learned from your parents and from your teachers as a young person?
There was indeed. There was. Flandern has a very strong Catholic tradition and also a tradition of missionary, sending out people to convince others, and maybe something of that stayed, because I'm still interested in what happens in the world and not sticking on just local issues.
And how was your education shaped by the events of the 60s? You probably were in the university at critical times during the 60s.
I entered in the university in 67, and this was indeed a very crucial element. Our generation was the generation that was confronted with very important changements. We had an education, a very strict traditional Catholic education, and then we were confronted with this whole movement of 68 that started in Belgium as a contest of strict local structures of the university, etc., and very quickly moved on to a very large movement of solidarity with Third World, Vietnam, and all these things came in.
And were you radicalized in that period?
I was like a lot of students at the time. I was indeed very quickly radicalized also by that movement.
And then, and was it just inevitable that you would do work in humanitarian international law, or did that just happen? Did you just come upon it?
Maybe it was a logical evolution, because at the time humanitarian law was not an issue. It became only an important issue in the 90s. When I started as a young lawyer, we wanted to work on very local issues of people discriminated people, migrants. We have in Brussels a very important population of migrants from Turkish and Arab origin that were in a quite difficult situation at the time, and better now, but there are still important problems. So I was for years working mainly on issues of immigration and asylum, and human rights issues, of course, are linked to that, and finally I became more and more interested in humanitarian law as well.
Before we talk about your work in international and immigration law, let's talk a little about being a lawyer, being somebody who does this kind of local and international law. What do you see as the skills, the prerequisites for being able to do this kind of work?
I think it's very important to have, first of all, good contact with the clients. A lot of people have a lot of legal problems, even problems that they don't immediately analyze as legal problems, but just the problems of life. But in fact, it's very important that you can see what the problems are really, and have a good contact with him, and then help him to solve these problems. And very often there is a solution also if you do your job in a good way. So
it sounds like you're saying that on the one hand, you need a broader picture of the context in which the person is situating who comes to you. But then on the other hand, you have to be able to communicate with them, because they may not come to you and know how to ask the right questions or understand their own situation.
Yes, that's right. A lot of our job is just consultation, even without having a case in the court. I have a lot of people just coming to have a talk on the problems they are facing and see how these problems could be solved legally. And especially for migrants, a lot of people are in a situation without documents, for instance, even if in fact they could be in a condition to get regularized or to get access to some things. Sometimes it's not possible, but sometimes it is.
In terms of the years that you've been doing this, has the makeup of this immigrant population changed considerably in the 20+ years since you've been practicing? Now they primarily, you were saying, are from Turkey and Morocco and so on. Is that a change that you've witnessed as you've been doing this work? Before they were from some other nationalities?
There is a changement in the origin of the people, but there's also a changement in these communities themselves. Very important. When I started as a lawyer in Brussels, the people from the first generation were workers, and a lot of them even couldn't speak French or Dutch, and were in a very difficult position. But today you have a new generation, and even some people from this first generation, well, they could make it. And we have, for instance, in the local administration, the part of Brussels where I'm living, an important part of the representatives in the local council are people issued from these communities. A lot of them are Belgian now, and I could witness indeed that transformation of a whole population.
And is the second and third generation more sensitive to their rights as they come to you in a way that previously was not the case?
And the problem is you have a kind of double evolution, because a part of the community indeed can quite seize the way they can get in the system, make business, buy houses, etc. And then you have another part, mainly young people who falls out of the system, confronted with drugs, confronted with criminal behavior, etc. And that's a very important problem. These people feel themselves discriminated, but at the other hand, there is no really also a self-organization to get out of that, and it's a very important problem.
Now, what percentage of the population of Brussels is this population that you're dealing with? Is it a small percentage, or is it got?
No, it's a quite important population.
Yeah.
From the Brussels population as a whole, probably 1/3 is from foreign origin, and in some areas, like the area where I'm living, it's half of the population.
Now, in terms of the part of your work that deals with immigration law, is it fair to say that it's the work of defining their rights as citizens of Belgium, what they are entitled to or will be entitled to as they become citizens? Or are they in a special category of people who really aren't citizens, don't plan to be, and are just there?
Well, a lot of these people are citizens, and in theory they have all the same rights as the others, but they are still in an economical category that has not access in practice to the same education and possibilities or to get jobs, etc. And you do have also some racism in the Belgian population. Mainly on the labor market, it is indeed a big problem.
Racism.
Yes, because a lot of employers prefer to engage people from Belgian origin, even perhaps to engage people, new migrants, either than young people who grown up in the streets in that kind of environment.
And give us an example of an important case related to these immigration matters. Let's just talk about immigration now, in terms of securing rights for people. I'm just curious as to both how the people come to you, what a particular case would look like, and even does the result have national implications for the country, so that by solving this one person's plight, you reach a broader category of citizens?
Well, an important case that I was handling was a case of an African girl that was an asylum seeker, because a lot of cases are also asylum cases, and she was expelled because they didn't believe her story, and there were a lot of attempts to organize this deportation because she was resisting. So
would she have been endangered if she had gone back to her own country? Was that the argument? Or?
That was she was pretending that she was forced to marry an older man, etc. And she really wanted to go back, so she resisted to deportation. And finally, the police people put a pillow on her face and killed her doing so.
Oh, gee.
So I was contacted by the Human Rights League in Belgium, and we lodged a complaint. There was an investigation anyway, but it was not easy even to have some police people prosecuted for that. They are still not convicted, but and the initial intention of the prosecutor was just to prosecute the two men who were beside her and to put a pillow. But they were executing orders, and the officers were also there. So we tried to enlarge the debate, and even a minister had to resign because of that. It started a debate on immigration policy and deportation policy.
And in cases like this, is the media important for you as part of the side of the work that you're doing to call public attention to the problem before the court?
Very often the media are important indeed. Of course, there are a lot of cases that are important and that don't have this media attention, and also in such cases you can sometimes succeed, but in some cases indeed it can be vital to have a support from public opinion, and if you need that, you need the media.
Now, you were until recently president of the organization called Lawyers Without Borders. Explain to us what that organization is and what it does.
Well, indeed, that organization in French is Avocats Sans Frontières, was created 10 years ago, and the model was more or less Médecins Sans Frontières, Doctors Without Borders. It means professional people trying to put their expertise and their knowledge on the surface of population abroad and human rights in general. So we had some very important programs, mainly in Central Africa, Rwanda, Burundi, also Congo now, organizing legal aids in cases of genocide, for instance, in Rwanda, and sometimes also assisting building up new justice systems after a collapse or after war, like in Kosovo or East Timor.
Mm-hmm. And what is the social base for this organization? That is, the middle-class lawyers who are driven by idealism, basically, to act internationally. Is that?
Yes, indeed. The
Yeah.
individual lawyers, some people also from important law firms that who wants to do something which is not only money making, but mainly individual lawyers indeed, who are involved in criminal law, because it's still the main part of our activity is in the field of criminal law.
Before we talk about universal jurisdiction and the cases that you've been involved in, let's talk a little about your philosophy of the law and your notions, your ideas about how law emerges, is changed, and moves in different directions. What can you tell us about how you see the law as a tool for social change?
I think indeed that as such the law is a very important element in a society. In our society you don't have the traditional basis of religion, for instance, who can keep things together. Especially in Europe, you have a lot of people with different philosophies, and there is no common morality. So the issue of human rights, the rule of law, and especially the human rights as a basis of the whole building, is a very important element for the social structure as a whole. And in Europe, for instance, you can also see that the principle of human rights becomes a basic principle in all aspects of life. You have the influence of the European Court of Human Rights in family law, in economics, in criminal law, and the idea of respect of the rule of law is also an idea that is and a reality that's very important for developing countries. I think, as for years we were thinking that that essentially the motor of development is economically, but as you see that the world is constantly confronted with war and genocide and dictatorship and torture, etc. If you cannot solve these problems, the economical takeoff becomes very difficult also.
And what then is the relationship between law and politics domestically, say in Belgium, versus law and politics internationally, and is the relationship the same in the two different jurisdictions?
I think that on the domestic level, law becomes also more and more important to influence politics. Mm-hmm. Also because of a lot of politics are no more free. I mean, traditionally, politics are the will of the people who elect their representative, and that's all. But you have a lot of other interferences now. You have principles coming from European law, from human rights conventions, international conventions in general, and politicians have to respect it. Also the population has to respect it. And I think the mentality is growing also that this should be respected. Mm-hmm. That even if the majority of a country wants to rid of all migrants, for instance, well, it cannot be accepted because it's contrary to some international principles that are accepted by all.
So that you're suggesting that the law is the nexus between the local community and its politics and the international community
Yes.
in a way,
Yeah.
and that there can be a positive feedback in the sense that if a particular country has not yet recognized certain standards for whatever reason, then the law is the way to make that known within the community.
Yes, indeed. Even if there is a setback, in some European countries, you had some extremists of right-wing extremists, for instance, who get very near of the power or who get in the governments, etc. But you can see that finally their power is very limited because we have this international framework of human rights conventions, etc. And the framework of the European Union that makes it, well, that makes that the possibilities of such groups are very limited. And this is a very positive evolution, I think. We should have this also on a world level. If we could have a better development of the structure of United Nations and of the international, the framework of international conventions, etc., well, I think it would be much more difficult also for individual nations to go against these principles and to launch wars, etc.
So in a way, what you're describing is a very European lesson, in a way, applicable to the wider world, in the sense that I guess in earlier periods, Europe thought, well, you could have fascism in Germany and Italy, and it wouldn't matter for the rest of Europe or for the rest of the world. But in fact, we found out that it did matter, actually. Has it been important for your work that you're actually based in Brussels, which in addition to being a capital of your country is also the home base for the European community? How has that dynamic, even if you're not practicing in European courts primarily, how has that dynamic created a synergy, a positive place for you to be doing what you're doing?
I think indeed Belgium has a special position because it's not really a big nation. We have two communities in conflict very often with each other, and we don't feel first at all we are Belgians. But we feel we are Europeans more and more. Belgians are feeling that we are in the center of Europe, and that Europe becomes something more important than the national states. That means that also the population is sensitive for some values that are common European values. It's not only a question of law, because you have also an aspect of Europe which is very bureaucratic, a lot of rules and concerning the way you can produce some things, etc.
So regulations
all
would interfere
kind of
with
regulations. But at the other hand, you have also some general values, and the Belgian society, also the Belgian political world, is very sensitive on that issue. That may also explain in part the position of Belgium sometimes internationally, and the fact that Belgium became also some laboratory for international law, for instance.
Now, so thus far you've suggested that the international community can have a positive impact on domestic law and change within the system as cases are argued in the national courts. Now, the whole question of universal jurisdiction is a different twist on this problem. So first explain to us what the concept of universal jurisdiction is, and I guess it was enunciated in documents called the Princeton Principles. Talk a little about what is involved here.
Well, the basis of universal jurisdiction is that you have criminal law in each country. You have laws saying that murder is forbidden, for instance. But you have also higher level. You have some principles shared by the whole world community. For instance, the fact that a genocide is something absolutely unacceptable, even if it is organized by law and even if it is not punished by the country concerned, it cannot be accepted by the humanity as a whole. In fact, these principles were elaborated already in the jurisprudence of the Nuremberg Tribunal and Tokyo Tribunals after the Second World War, saying that even if something is not mentioned in the national law, these core principles of humanity should be respected. And the consequence of that is also that if the local courts cannot handle that kind of cases, cannot prosecute that kind of crimes, there is a global responsibility of the international community to do so, to prosecute such crimes and to bring perpetrators for their own courts. Of course, the ideal situation is to have a global international court that can handle all that cases.
Such as the International Criminal Court.
Such as the International Criminal Court, even if the ICC has some limits. For instance, there is no jurisdiction for the past. But it's a very important step in the struggle for international accountability.
Now, so what then happens? I mean, it would seem then head of state X commits a crime in a country. Ideally, the crimes would be brought to the International Tribunal. If that's not possible, then the charges against him would be brought in his own country. Mm. But I guess in universal jurisdiction is the notion that he can be tried, or it doesn't have to be a head of a state. It could be a military functionary or a civil servant or just a private citizen, that they could then be tried in another country. And this is, in fact, what the Spanish jurists tried to achieve in the Pinochet case by bringing charges against him for crimes he committed in Chile, but after many years after the fact, but while he was traveling in Britain. That's the idea.
That's indeed the idea. The Pinochet case was a very important landmark, of course, for universal jurisdiction. And it shows also that it is something that is not just symbolic or virtual justice, but that can be really practiced because also of the international cooperation between states. In Europe, we will have now the European warrant of arrest. It means that if a Belgian judge issues a warrant of arrest, it's automatically respected by the whole European Union. Indeed, it's not a question of Belgium that decided, for instance, that we want to judge everybody. It's a global responsibility for the international community.
Now, how do you respond to people who make the argument that such judicial interventions in a particular country that is not the citadel of either an international court or of the local court, that it can affect negatively the politics within the country where the act was committed and the dynamic by which reconciliation is achieved. So, for example, in the case of South Africa, which was able to peacefully, relatively speaking, move to a transition, commissions, truth and reconciliation commissions were set up where people, the community appeared willing to accept the idea that not everybody would be brought before a court of justice if, in fact, they would openly admit their crimes of the past and so on. What I'm trying to get at here, is there a a problem with efforts to, say, try a former apartheid official in another country that would interfere with that balance that was established in South Africa?
Well, in fact, the practice of universal jurisdiction is raising a lot of problems, also because it is a new field of law. Countries are making mistakes and are learning from that mistakes, and international case law is to be developed, etc. So I'm certainly not saying that the somehow anarchic situation now is a perfect situation. And the example you are giving from South Africa is indeed a problem that's to be taken into account. I think that countries should respect an internal process of reconciliation if this is a real process of reconciliation, not like in Chile, where general amnesty is forced by the former dictator. But if there is some form of accountability, and if also the victims' rights are taken into account, even if it's not perfectly done, it should be respected indeed.
And what are the guarantees that, you know, this kind of calculation that you've just suggested is the ideal? What are the guarantees that they will always be followed in particular jurisdictions? I mean, I guess what I'm sort of wondering about is, let's take the American domestic situation where we developed the notion of a special prosecutor, which was very useful at a particular time in our history at the time of Watergate, but 20 years later became something else and was used to go after a sitting president for apparently ideological reasons as opposed to a legitimate mandate for a special prosecutor. So what I'm curious about is, what are the mechanisms if you're applying universal jurisdiction, say for example in Belgium, that the charges that are being brought will be, will be responsible ones, in light of the calculus you're describing?
I think that the judiciary will develop some principles and some guidelines, but that also countries should think upon it and maybe negotiate, for instance, some international conventions on that. And I think certainly on the European level it will become possible. There is already a European decision to appoint in each country a focal point for war crimes and crimes against humanity. It's mainly one officer of the prosecution, for instance, which is responsible for the contacts with other European countries. And next step could be to negotiate some convention like we have now in the field of asylum. The principle of asylum organized by the Geneva Convention is not implemented the same way in each country. But there are some rules on the European level to say that in such kind of conditions, this country will be responsible to handle it. And the next step, which is under construction, is also some basic rules for the procedure.
So what you're suggesting is that it's a misperception to perceive what's happening now in the various universal jurisdiction cases as the final output, in a way.
It's just the beginning.
Yeah, it's the beginning. Yeah,
yeah.
it's the beginning of a process to define a body of international law that would have meaning.
Yes, indeed,
Yeah.
indeed.
Yeah.
It's a field of international law which is still in its child period. It will grow up and it will develop, and it would be a mistake to see only the problems now and to say we have to stop this because it's provoking problems. We should try to solve the problems.
Now let's talk about two cases that you've been involved in this regard. You were involved, I believe, in a case involving Belgian troops in Yugoslavia, or were they
In Somalia?
In Somalia. So what are the issues that came up, and what was the purpose of bringing the case, in Belgium? The case was, tell us a little about the case.
Well, indeed, Belgium participated in a peacekeeping operation in Somalia, and it was discovered by the press that there were some abuses by our soldiers, some racist behavior in front of the local population, and a lot of things stories came out in the press. So the Center for Racial Equality, it's a public center in Belgium, decided to start to force an investigation and to have these people prosecuted. So I was appointed in that case, and indeed we could achieve that. There was an investigation, and finally also some people were convicted for racist behavior. I think it's a good example how the things can go. Of course, it's not necessary that such a thing is judged by international court or by another country, if the country can handle it itself. So the first forum to handle this is indeed the country where the perpetrators are, or the country, of course, where the offenses occurred. But in this case, it would have been difficult to imagine that judiciary of Somalia could handle it.
Now, in a case like that, and it may be too recent to comment on the conclusion, but does that affect the rules by which the military defines its operations? So what is involved in this verdict is not just bringing to justice the perpetrators, but in fact to have the political impact of how your soldiers are trained to behave in situations like that?
Of course, if you are punishing murderers, for instance, the primary purpose is to avoid that people are killed. So the function of criminal law is to avoid crimes. And it's also the same, of course, for international crimes. The problem is that a culture of impunity is encouraging crimes. And if people know that there is a risk of prosecution, we can hope that at least they will take it into account, and that it will reduce the scope of that kind of crimes.
Now, another important case that you're involved in is the suit in the Belgian courts that has been brought against Ariel Sharon, who's now the sitting Prime Minister of Israel, for actions he is alleged to have taken in maybe 20 years ago in Lebanon. Tell us a little about the facts of that case. First of all, how it came before your law firm. Who were the people bringing the complaint, and what was the complaint?
Actually, it came through a Lebanese colleague, Mr. Shibli Malat.
Who's a Belgian lawyer?
No, who is a Lebanese lawyer.
Okay.
And who was in contact with the people from the camps who were looking for a possibility of an international investigation for that crimes in Sabra and Shatila in '82.
Okay, and let's explain. These were Palestinian camps in Lebanon.
In '82, there was a war launched by Israel against Lebanon. Israel occupied Beirut. There was an agreement with the PLO that had armed forces in Beirut to withdraw. An agreement was broken even by organized by the American Special Representative Philip Habib.
Right.
And the agreement was that after the withdrawal of the Palestinian fighters, also the Israeli would withdraw. But in fact, Ariel Sharon decided to occupy the whole city, also the areas formerly under control of the Palestinians and leftist Lebanese group.
And this was in his capacity as defense minister? Was he defense minister?
He was defense minister, and as defense minister, he was also in charge of the war operations in Lebanon. He was personally and directly commander also of his troops. He was not just sitting in his office in Tel Aviv. And the killings were not perpetrated by the Israeli army, although maybe there were some, but mainly it was done by Christian phalangist groups, but who were allied to Israel and to the Israeli army, and who worked together with them.
So just to explain a little more, so we had a civil war going on within Lebanon, and so one of the factions, one of the groups involved in that civil war was aligned with Israel, and they were the ones who went into the Palestinian camps.
They were practically auxiliary troops of Israel. They were trained in Israel, they were armed by Israel, paid by Israel. And when the chief who was elected as president was killed, not by Palestinians, finally they discovered later on that the Syrians were behind it, Ariel Sharon ordered them, convinced them to get in these Palestinian camps and to clean the camps from so-called terrorists stayed behind. In fact, they were not armed forces behind. They were just civilians, mainly women and children and elderly men. And during 3 days, there was a random killing of hundreds, maybe thousands of people under the supervision practically of the Israeli army who was surrounding the camps, giving lightning during the 3 nights when the killing was going on. And they could very well see what happens, but they didn't interfere and they didn't ask even to stop the killings.
Now, within the Israeli legal system, there was was it a military tribunal to examine the circumstances of this?
No, that's exactly the problem. That there was never judicial investigation or judicial procedure to handle that. Even the leaders of the Phalange were not arrested by the Israeli. They were still allies also after that event. And there was under the pressure of the Israeli population itself, because there were a lot of demonstrations. 400,000 people were demonstrating, and even an Israeli guy was killed in such a demonstration. So finally, the government set up an investigation commission. But this commission didn't have any authority to prosecute people and only to give some recommendations to the government. But still, the commission concluded that some people, and in particular Ariel Sharon, had a personal responsibility for what happened.
So the issue had never publicly been resolved, or a final determination within Israel by a judicial, committee. Now, so what were you?
There was a political sanction because Ariel Sharon had to withdraw as defense minister.
Right.
And there were some sanctions also against generals, etc. that were moved from one function to another.
Right.
But there was no judicial solution, and the rights of the victims were not taken into account. There was never any compensation for the victims, for instance.
So what is the case that you then brought, and where did you bring it?
Well, we were contacted by 28 people, survivors or family members of people killed. Some of them were injured in these events, and they wanted us to use the Belgian law on universal jurisdiction to start an investigation. That was what we have done. We started that investigation, and we are still continuing it, although, as you know, there are a lot of legal complications, and there is a very huge pressure from Israel that even withdrew his ambassador after the Supreme Court of Belgium confirmed that our claim was completely legal.
And the complications here come from the fact that Sharon is now the sitting prime minister of Israel, and but were the people who brought the case through you in the Belgian courts, are they citizens of Belgium, or they're Lebanese?
They are Lebanese or they are Palestinian, stateless people, most of them, and indeed they came only to Belgium to launch the complaint.
Okay, and Belgian law allows for this,
Belgian
or it did allow for it,
still
allows for it.
Still allows. The new law, as it was adopted some weeks ago, provides that in the future, if there is no link with Belgium, either on the side of the victims or on the side of the perpetrator, if there is no link at all, the public prosecutor must confirm the complaint and must decide that an investigation or a prosecution is necessary. Before, a victim could, on its own initiative, force an investigation without any approval of any authority.
Now, in a case like this, on the one, it sounds like there are really two aims. One is to get restitution or justice for the individuals who are involved and who represent a class of people. But on the other hand, to achieve what in international law? I mean, is the purpose here the notion, well, if this can happen, that is charges brought against Pinochet or against a Sharon, then, or a Milosevic, it is a warning, you know, that the international community is not ready to tolerate these kinds of actions, even if the national jurisdiction won't move on them?
Well, indeed, from the perspective of the victims, of course, it's to have recognition of what happens and of the responsibilities of those who are responsible, and to have compensation and redress. But from international perspective, indeed, the fact that this is possible is indeed a pressure also not to repeat such things. And in the situation of Israel, it's not just a theory, because there is still a risk of new war even with Lebanon. And the fact that Mr. Ariel Sharon was involved in that case in the Lebanon war, and that he's now prime minister, makes also, from the perspective of our clients, that there is a risk that such things could happen again in the future.
And ideally, because obviously one could make the argument that if such a proceeding like this happens, you know, that in the future attorneys less responsible could bring charges against a former military official who is now a prime minister in some hypothetical country, you know, and the validity of bringing the charges was a more open question, let us say. But you've suggested earlier, and also in this change of law in Belgium, that the idea would be that there would be mechanisms in states to evaluate whether this particular claim in a particular case, this particular lawsuit, should be brought, you know, in the context of both international justice and the broader interests of that particular state. Is that too confusing? I
well,
mean,
that's more or less what's happening now in Belgium, because we are some kind of laboratory the last years. The fact that we have a global law on universal jurisdiction, but also a law based on the continental system, where victims have very large possibilities to start an investigation, made that a lot of complaints were lodged in Belgium against a lot of people going from Castro, Rafsanjani, Arafat, etc. A lot of these cases were frivolous, and the plaintiffs were even not really bringing elements of evidence, etc., but just were looking for some media effect. So the new law that was accepted now wants to limit that kind of
frivolous,
frivolous cases.
Action, yeah.
So first of all, it will become more difficult if there is no special link with Belgium. There will be more responsibility for the prosecutor. And the last guarantee, which personally I regret, is that also the government will be able to stop an investigation in some conditions. But these conditions are very large. It's sufficient that the country concerned provides for punishment for war crimes or crimes against humanity and grants fair trial for the parties concerned. But once these both conditions are
adopted,
yes, it can be possible to stop the case, even if there is no guarantee at all that there will really be a prosecution in the country.
So in short, politics can interfere with the ethical possibilities in the process.
Indeed. Belgium, of course, is a small country.
Yeah.
And depends also economically from others. There were very important pressures from Israel, but even from the United States, because recently was also lodged a complaint. I will not say that it is frivolous, because it's not up to me to judge it, but it was launched on a very non-opportune moment, just at the eve of the new Iraq war. A complaint was lodged against Father Bush Sr. Because of a bombing of a shelter in Baghdad during the first Gulf War. And the reaction of the United States also was very heavy, not spectacular, but Belgium was informed that NATO headquarters could be removed from Belgium if the government didn't find a solution for that.
So what you're suggesting is that one of the things in the future that has to be worked out if this process continues is a fine-tuning that allows a separation of frivolous cases that also may be political dynamite, but that needs to be separated from bringing a valid case that actually may be political dynamite also. Yeah.
And in my opinion, this kind of fine-tuning should be done by judges or even by the prosecutor, but not by the government.
If students were to watch this tape, what advice would you give them? What should they do to prepare for the future if they're interested in participating in these processes by which these elements of international law are being shaped and defined?
Well, I think it's a field of law that certainly will develop in the coming years. Also with the development of the International Criminal Court, of course. I think that the legal community in the United States should support the ratification of the Convention on the ICC by the United States. It's a very bad thing that the United States does not participate in it. And it will also make the organization of the ICC will also be an element that will structure and organize this whole field of international criminal law and avoid, maybe not completely, but will help to avoid a lot of bad experiences on the local level. Another thing is that also lawyers have a personal responsibility in lodging some cases and complaints. You should not only act politically when you are accusing someone. You have a responsibility as lawyer also, because you have a responsibility up to even if the person you're accusing is had a very bad behavior, well, he has also his rights of defense, and You cannot accuse someone if you don't have serious elements in your file. And you have also, indeed, you were giving in the beginning of our discussion the example of South Africa. You have other countries where indeed an initiative on the international level can have a negative influence in the local situation. Mm-hmm. You can have exactly the same here in the United States with a procedure based on the Alien Tort Claim Acts, for instance. That makes it possible to pronounce very important amounts of punitive damages against people from other countries, etc., and to have, in fact, an influence on the situation of that country.
Mm-hmm. One final question: looking back at your life, what are the common themes that sort of unify your efforts? It sounds to me like I heard that there was in a way, a kind of a search for an ethical dimension in a secular world. That you were suggesting at some point that law and international law and domestic law are an instrument for maintaining and furthering that ethical dimension, even in a world where religion is doing less of that.
Mm. Well, for the future of the world, I think that the rule of law indeed will become more and more important. And I hope indeed that the development that we could witness in Europe with a large development of international law and conventions, but also with some structures, judicial structures to control it. I think this is a very important element to get the world secured. And it's very necessary also that we can proceed with that. And I think it's very regrettable today that, and especially after 11 September, that countries are falling back on their strict own interests and just doing a power play, as they should understand that even the national interest is linked to the interests of other countries. What happened on 11 September in the United States is not only a question between the United States and Al-Qaeda, but it's linked to the whole problem of the Middle East, of the situation of the Third World, etc. And we should solve this kind of questions together, even if it's much more difficult to get a solution together than to do it yourself. I think it's really necessary, and I hope that in the future we will go that way.
Luc, thank you very much for joining us today for this fascinating conversation about your intellectual journey and the future of international law. Thank you.
It was a pleasure.
And thank you very much for joining us for this conversation with history.